All right, in this video I'm going to spend a little bit of time talking about the history of civil rights in this country. And I'll focus on events leading up to important civil rights legislation like the Civil Rights Act of 1964 and to the current interpretation of the 14th Amendment. In telling this story, I'm going to focus on the history of African American rights and also of women's rights. And I'm going to tell the story together. They do run alongside one another, affect each other at various points, and the story is of the two movements is really quite intertwined. So let's begin during the founding period. Certainly during that early period, African Americans were affected by the institution of slavery. There were some free blacks, but their rights were sparsely enforced, especially in the South. Women were affected by a legal notion called coverture, in which a woman's legal identity was covered by her husband's when she got married. Women during this early period, were not understood as having a separate legal identity. And partly because of this, and also partly because of tradition, women were not afforded any political rights. When she became married, her property became the property of her husband. She didn't have child custody or divorce rights, and there were pretty strong societal norms against women doing things like speaking in public. Now, the abolition era begins to bring women into the public sphere in a strong way for the first time. The abolition movement, of course, is the movement to end slavery. And Northern women, especially in the churches in the North, were involved in this movement. And they learned two really important things as a part of this. One was organizing skills. They began to be familiar with the importance of who to invite to what meeting and the importance of serving good food to make sure people showed up and things like that. They also learned, as a part of being involved in the abolition movement, the language of rights. And this is really important. I mean, the language of rights was a fairly new thing in the world. And the way that this language works is one applies that language to one situation, and then it becomes evident that it also applies to another situation. So, for instance, when women became skilled in talking about the rights of slaves and how slaves did not have rights to their children and to their wages and things like that, they also began to say, wow, neither do I. I don't have those rights either. And when that happens, an important transformation begins to take place in which women began to advocate for their own rights. There was an important moment when two abolition organizers, Elizabeth Cady Stanton and Lucy Stone, traveled to England in 1846 for the World Anti-Slavery Convention. They went with their husbands. It was an arduous journey. And they got to this meeting in England and were told that they were not allowed to participate because they were women. This was kind of a shock to these two women. They were Quakers and not used to being excluded in that way. And so when they came back to New York, decided that they needed to call a convention for their own rights. And so this was the birth of the first women's rights convention in the United States in Seneca Falls in 1848. There were about 100 people that attended that meeting. About 2/3 of them were women, about 1/3 were men. And they produced a document called the Declaration of Sentiments, which begins, we hold these truths to be self-evident that all men and women are created equal. And, of course, it's modeled on the Declaration of Independence and includes a list of all of the grievances that men have perpetrated on women over time, and a call for rights. They called for a lot of different rights, things like child custody rights, divorce rights, property rights especially, but they were divided on the question about whether to call for the right to vote. Many of the participants, even about half of the women who were there in 1848, were convinced by this notion that the vote should be for a household and not for individuals. And so they were uncomfortable with the idea of women having their own separate vote, separate from their husbands. So one can anticipate it's going to be a long struggle. Now, during the Civil War era, women put their movement on a hold to help out with the war effort. And after the Civil War was concluded in 1868, when the 14th Amendment is put into the Constitution, they were shocked to see the word male in that amendment. And as I've already mentioned, they tried unsuccessfully to argue that person included women. We talked about that when we talked about the originalist versus the living Constitution view of the interpretation of the 14th Amendment. The next step, though, was the 15th Amendment. It was clear that the 14th Amendment was not going to compel states to extend the right to vote to the former slaves, and so a 15th Amendment was drafted. And the language of the 15th Amendment is that the right to vote shall not be abridged on the basis of race, color, or former condition of servitude. And when that language was drawn up, the women in the women's movement objected to it and said, no, we need to add sex to that list. And but there was division on this question, and so they called a public debate about whether they should support the amendment as it stood or whether they should hold out and demand that the word sex be added to the amendment. At this public debate, there were some important people there, including Susan B. Anthony and Frederick Douglass. Frederick Douglass was himself a former slave. He had actually been in Seneca Falls in 1848 at that early convention. He was a strong advocate for women's rights. When they asked his opinion on this, he made a very important and well-known speech in which he said that he thought that they should just move ahead and not put sex in the amendment. He was worried that it would stall the forward progress, and he was insistent that slaves had suffered much more than women and that they should at least have their rights. Susan B. Anthony was also there and was very upset with this stance and said that no, certainly they needed to hold out until the word sex was added to the amendment. And she challenged Frederick Douglass that certainly he would never want to exchange his sex for her. And, sort of making the argument that her oppression was more fundamental than his. So it's this kind of sad event that happens sometimes. You get the two oppressed sides sort of fighting for the crumbs that are falling from the power structure, fighting about whose oppression is the most fundamental, right? Now, they also asked Sojourner Truth her opinion. She wasn't at the meeting, but she was herself a former slave, and asked her what she thought, and she said they should definitely hold out and add sex to the amendment. And her reasoning was, number one, while the ball's rolling, keep it rolling. She thought that they'd be more likely to get their rights, that everybody would get their rights if they stuck together. But she also said that she thought that she'd be just as likely to be oppressed by the black man as she was by the white man. In any case, sex was not added to the amendment, and it was ratified in 1870, and ostensibly gave the right to vote to African American males. And we'll come back to this. But what happened with this debate was that it resulted in a split in the women's movement. They came out of this period, two different movements, Lucy Stone on one side with an organization called the American Women's Suffrage Association, and Elizabeth Cady Stanton and Susan B. Anthony on the other side, forming an organization called the National Women's Suffrage Association. The AWSA was more conservative and, didn't have as much of a problem with women's separate role in society. The organization also was focused almost exclusively on voting rights. They didn't challenge other kinds of conventions as much. And they also took a state-level strategy, trying to focus on changing state laws to give women the right to vote. And they also focused on organizing at the state level and forming chapters in every state. The National Women's Suffrage Association was much more radical in the way that they understood women's roles. They challenged the separation and these social conventions. And they also turned their attention to many other issues besides the right to vote, including birth control, which was something that the AWSA would never have taken a stance on. The NWSA also focused on a national level strategy, trying to organize at the national level and focusing on trying to get the Constitution itself amended. One of the central differences between these two organizations as well was how they justified the right to vote. The AWSA took a much more pragmatic stance in the way that they understood why women should have the right to vote. And they thought that women should have the right to vote because they're different than men and they're going to vote differently. And to the extent that one thinks that things should be done differently, women might help with that. The NWSA took a very principled stance on this, and they said that women should have the vote because they're the same as men. And it doesn't matter in particular what women end up doing. They should have the right to vote simply because for the purposes of voting, they are the same as men. Now, African Americans after the Civil War really were faced with a very hostile environment after the end of Reconstruction. Reconstruction ends with the election, presidential election in 1876. Up until then, the North and had provided troops to protect the rights of African Americans and to redistribute property as well. But when Reconstruction ends in 1876, things began to really turn. And the new amendments that had been added to the Constitution in 1868 and 1870 didn't really help. The 15th Amendment, for instance, the right to vote, was blocked with all kinds of different voter suppression laws, including poll taxes throughout the southern states, literacy tests, and widespread violence and intimidation. So, for example, some of the literacy tests that were required in the different states, if you look at these questions, they're just really hard questions about government. If you thought the questions I asked that might be asked in the citizenship test are hard today, look at these questions. In what year did the Congress gain the right to prohibit the migration of persons to the states? Who was the Commander-in-Chief of the Army and Navy of the United States? These are questions that, even people who teach government in some cases might not be able to answer exactly all of them. And here's another example of a different type of literacy test that was given in Louisiana. Kind of tricky and really pretty silly questions. Now, a lot of white people in the South also couldn't read and probably couldn't pass these tests. And this is the role of the grandfather clause. The grandfather clause held that if one's grandfather could vote, then they wouldn't have to pass this test in order to vote. And of course that meant white people. The 14th Amendment as well was not very useful to African Americans during this period. This of course includes a clause, the Equal Protection Clause. Let me just flip up here and show you that language very quickly. No state, this is the 14th Amendment, no state shall deny to any person within its jurisdiction the equal protection of the laws, right? Just so that we can remember what that language says. Now, what started happening in the South is the emergence of segregation. So schools were segregated, public facilities were segregated, businesses were required to be segregated. And in 1896, a case made its way to the Supreme Court challenging these practices. It was called Plessy versus Ferguson. And what had happened is Homer Plessy had been riding on a train car. And in that state, in Louisiana, it was required by law that the trains provide separate cars for African Americans and for white people. And so he was in the wrong car. He was prosecuted, and the case went to the Supreme Court. And in that case, the Supreme Court said that as long as the facilities are equal, it's okay to have them be separate. And their rationale was that as long as it's the same law that requires African Americans to be in one place and whites to be in another, it's the same law that applies to both, so the law is being applied equally, right? Now, from our perspective, of course, this seems like a very kind of tortured reading of the Equal Protection Clause, but that's the way the court understood it at that point. And it led the way to even more widespread Jim Crow segregation throughout the South. Women during this period, the two organizations continued separately to work for the right to vote until in 1890 they reunified in one organization now called the NAWSA, National American Women's Suffrage Association. And Susan B. Anthony is chosen to head the new organization. The organization is takes on many of the very conservative values of the AWSA, partly because it had attracted so many members with the Prohibition fight, where the AWSA at this point had hundreds of thousands of members. The NWSA had about a tenth as many members. And so it was clear that if the Anthony and Stanton were going to be involved, they were going to have to be involved with the AWSA, and so they merged their organizations. It also is this period at the end of the 19th century, beginning of the 20th century, is really one of the most overtly racist in our country's history. It was perfectly acceptable to adhere to a white supremacist understanding of the races. And during this period, the women's movement is also affected by this. So there are chapters throughout the country segregated by race. In Chicago, for instance, there's a white chapter of the Suffrage Association and a black chapter. And Susan B. Anthony sort of turns her cheek to this and allows this to happen, and really in favor of the possibility of getting the right to vote for women. It's so interesting and so ironic to think about how that relates to the debate over the 15th Amendment in 1870. Now, the other thing that this new movement does is it takes on the strategy of the NWSA, which is to focus on amending the Constitution. By this point, after 40 years of fighting for the right to vote for women, the right to vote has stalled. And this is a map that was published in the New York Times in 1911 that shows what is happening on this issue. We have 3 different kinds of countries here. We have some countries that have full suffrage for women, including California and the western states. Women can vote already on everything from the dog catcher to the president. They have the right to vote. The earliest state to give women full voting rights was Wyoming in 1868. Before they were even a state, women could vote on every single measure. And so it's not, it's not clear, it's not the case that women didn't have the right to vote until 1920 when it went into the Constitution. It depended on the state that you lived in. We also have some states where women have no voting rights at all. Many of the southern states, of course, are in this category. But we have lots of other states, too, many of the Midwest states and a lot of the northern states, and in which women had school and other forms of partial women's suffrage, is the way that the New York Times phrased this. Now, what that meant was that women were not allowed to vote on everything. They could vote on some things, but not other things. So, for instance, if it was an issue affecting the schools, they'd let women vote on those questions because men would say, well, I'm a man, I don't know anything about the schools. Let's let the women vote on that. But other kinds of issues like taxation, the presidency, women were not allowed to cast a vote on those issues. And so what had happened was that with this rationale that the pragmatic rationale that women should be allowed to vote because they're different than men, what had happened was that meant that they would only let women vote on things where they thought that they were different from men. And so this was not very helpful. So there was a recognition that they had reached a kind of a stalled state, and that they needed to push this to the constitutional amendment battle. Now, African Americans during this period, you could sort of think of their response to the violence, the denial of rights, the Jim Crow segregation in 4 different ways. First, some of them just tried to kind of survive and stay under the radar screen as much as they could. Another strategy was simply to leave the South, and that is what many of them did. This is the period we call the Great Migration. In 1910 to 1940, about 1.6 million out of 13 million African Americans leave the South. And the pace picks up between 1940 and 1970. 5 million out of 23 million leave. Enormous numbers of people flooding out of the South. During the early period, they're going to the northern states, the big cities, to seek factory jobs. And then the second period, they're continuing migration to the north, but they're also beginning to come west. A third approach is what you might refer to as the legal strategy, trying to overturn Plessy versus Ferguson. Now, of course, most people are not involved in this. This is strategy of lawyers. But there's a recognition that until they can get rid of constitutionally sanctioned segregation, it's going to be very difficult for African Americans to get ahead in society. And so a series of cases are brought to the courts trying to convince the Supreme Court to overturn Plessy. They finally succeed in a case called Brown versus Board of Education in 1954. And in that case, the court holds that separate but equal is not okay. They changed their mind on that question. Now, it's important to understand the rationale of this case. What we mean by rationale is, what is the reasoning of the court? What reason do they give? And it's very different than some of the cases we'd seen before Brown versus Board of Education. Early cases had focused on the equal part, the separate but equal, and they had said, boy, this facility is not really equal, and so this accommodation is not okay. So, for instance, there was a law school in a state. There was not a law school for African Americans, and so they were able to bring a case to force the state to allow African Americans to attend the white law school, because it wouldn't be equal otherwise, because there was not a black law school available. But what they did was that, they would force the African Americans to put their chairs in the hallway, and they couldn't actually sit in the room. They'd have to kind of try to listen in. They were not allowed to use certain parts of the library. They were not invited, of course, to any events on campus. And so they were able to show, boy, this is not equal, and force the law school to make changes to their policies. But what Brown versus Board of Education did was quite different. They produced research that had been done by sociology students at the University of Chicago, showing that African American children who were in segregated schools were affected by that. So they did an experiment, for instance, where they asked the white children, why do you not go to the same school as the African American kids do? And the white children would say, well, it's because we're better than they are. We can't go to the same school. And when they asked the African American children, how come you don't go to the same school as the white kids? The answer was the same. We're not as good as they are. They're smarter than we are. We have to go to different schools. And so they were able to convince the court that separate is inherently unequal. It can never be equal. So the focus shifts entirely from trying to make the facilities equal to getting rid of segregation. Now, the case Brown versus Board of Education was only focused on education and not on other facilities like public swimming pools and things like that. But those things come later. Brown was met with a lot of resistance on the part of white parents in the South. And in some states, in Charlottesville, for instance, in Virginia, rather than comply with Brown, they closed the entire school system down for about 2 years, and were able, what happened with that, of course, was that African American kids went without any school for a couple of years. White kids, though, the parents pooled their money and were able to pay teachers under the table to teach in people's homes. This was another kind of thing that happened, was that tax money was diverted to private schools that would only admit white kids. And this is one of the issues that Hillary Clinton was involved in when she was a young graduate student. She was working to show that one of these all-white private schools was set up specifically to avoid Brown versus Board of Education. Another example is, of course, what happened in Little Rock in 1957. In Little Rock, the governor of the state of Arkansas refused to allow the schools to be segregated. He called out the Arkansas National Guard to block the school. The school district, in trying to comply, had asked for African American volunteers to attend the white high school for the first year. And there were 9 volunteers. We called them now the Little Rock 9. When the governor called out the National Guard, it was an extremely tense situation. And the president at the time was Eisenhower. And Eisenhower was not going to let this happen. He wasn't going to allow some governor down in Arkansas to kind of thumb his nose at the Supreme Court. And so Eisenhower called out the Army, actually the 101st Airborne, and sent them to Little Rock to escort the 9 kids to class. And this is a picture of the 101st Airborne taking them to class. Those soldiers escorted them to class every day of the school year for the entire year. Took them to class, went to their house in the morning, escorted them to class, stood guard outside the classroom, brought them home at the end of the evening. This was the federal government really asserting its authority over the state government, and it was the beginning of the end of this kind of white resistance to overt segregation. Of course, it doesn't put an end to segregation entirely, but changes course. A fourth approach, of course, is a political movement. And the political movement would be directed to changing the laws from the legislative side of things. The political movement, we see it really taking on steam in the 1930s through the 1950s in the churches in the South. And in 1955, the Montgomery bus boycott has some success. What had happened was that the city government had required that the buses be segregated by race, and the African Americans decided they're going to boycott the bus line until that rule is lifted. Now, in order to understand that, we need to realize that bus lines at that time were a lucrative private business. It's not like today where the bus lines are run by the city governments and they're pretty much subsidized by taxpayers. That was not the case because a lot of people in the South in the 1950s didn't have their own car. They relied on the buses, white people as well as black people, and especially a lot of white women. It was not acceptable for white women to drive themselves, and so many of them relied on the bus lines. And when Rosa Parks was arrested for refusing to give up her seat on the bus to a white man, this boycott began and continued for the better part of a year until the city relented and took back the rule and allowed the bus lines to desegregate. In fact, the owners of the bus lines were kind of asking the city, could you please rescind this rule, because they were losing money and wanted to get back into business. This is the first involvement as well of Martin Luther King in this in the national scene, and propels him into a leadership role. in the civil rights movement. And his ideas, influenced by Mahatma Gandhi of nonviolent civil disobedience, become the tactic of the civil rights organizers in the 1960s, who carry out thousands of marches, protests, sit-ins, etc. The main successes of all of this were the passage of the Civil Rights Act in 1964, which prohibited the discrimination on the basis of race in private employment and also in public accommodations like restaurants. And then a year later, after more violence in Selma in Alabama, the Voting Rights Act of 1965 is passed. Now, just to flip back quickly to the women's movement, when I didn't come back to this, but when the women's movement reunifies in 1890 and they begin to focus on constitutional amendment, they are also carrying out protests, marches, picketing the White House during World War I, which was seen by many as an act of treason. They were finally successful in 1920 at getting the 19th Amendment ratified. It was passed by Congress first in beginning of in the end of 1919, and then they went out for ratification. In 1920, it was finally ratified, that giving women the right to vote in all of the states. It's worth telling the story of the final ratification vote. Remember, they need 3/4 of the states, and when they were in each of the state houses, the state legislatures where these votes were being held, women from the movement would attend these votes to kind of watch and see what was going on. In the vote in Tennessee, they're to the point now where they only need one more state, and they're in Tennessee. And if the vote is successful in Tennessee, they will have reached the threshold. And if it's not, then they'll have to go on to another state to try to reach that threshold. And as a practice, the women would kind of ask the men as they walked in to the state legislature if they were going to vote in favor or opposed to the amendment. And by their count, they were one vote short. But when the vote was actually held, there was somebody changed their mind, and in the very last minute, the amendment was ratified in the state of Tennessee, and at that moment became a part of the Constitution nationwide. And so the women looked around and tried to figure out who it was who had changed their mind at the very last minute, and it was a guy who was the youngest member of the Tennessee State House. He was only 24 years old, and they asked him, why did you change your vote? Why did you vote in favor of suffrage? And he took out a letter in his pocket that had been written to him by his mother, and in the letter said, be a good boy, vote for suffrage. And so he said, I reason that a mother's advice is always best to follow. Nice little story. And so the 19th Amendment is ratified. But when it's ratified, it is the law of the land, and has to be enforced in every state. States don't try to block the 19th Amendment as they did the 15th Amendment, because after all, these are their mothers and their sisters and their daughters. But there were a lot of states that were still not quite on board with this. There were several more states that ratified as a symbolic gesture In the 1930s, in the 1940s, states continued to ratify. And then the very last state to finally ratify the 19th Amendment as a symbolic gesture was Mississippi, who finally ratified the 19th Amendment in 1982. And it wasn't for lack of trying. It was brought up every year since 1920 in the Mississippi legislature. It wasn't ratified until 1982. I mean, the resistance to this notion that women should have the right to vote continued, and it was focused on this, this idea that the family is a unit and shouldn't be divided. And there was a lot of concern that still lingered that this would sow division within the family and weaken the family unit. Now, once the right to vote is secured with the 19th Amendment in 1920, the predictions that women are going to vote differently than men turn out not to be true, actually. Until 1980, the best predictor of a woman's vote was how her husband voted. But after the right to vote goes into the Constitution, there are still lots of other issues that remain. Issues like employment discrimination, the social divisions, the idea that the women's place is in the home, the legal disadvantages, and these things would have to be settled by some kind of an equal rights amendment. And there was one first proposed in 1923, and sort of languishes and doesn't get very much attention until the women's movement reemerges in the 1950s and 1960s. We call this the second wave of the women's movement, which was focused on those kinds of issues. And the ERA is sort of dug up again, and it passes Congress in 1972, but it's ratified in only 35 of the 38 states that are required. And you can see the language of the Equal Rights Amendment here. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. And again, it's the southern states primarily that failed to ratify the Equal Rights Amendment, which is essential now. But there were some successes, and one of these was the passage of the Civil Rights Act of 1964. That act, which was drafted really with the idea of African American civil rights in mind, a white legislator from the South added an amendment that included sex in the Civil Rights Act of 1964. So the suggestion that in employment one could not discriminate against women either. And it's unclear why he added that, but some people think that it was actually a strategy to ensure that the Civil Rights Act of 1964 did not pass. But it did, and so it included women as well as African American men in their protections against employment discrimination. The 14th Amendment as well, for many years, have not been particularly useful for women. And in 1971, this changes with a case called Reed versus Reed. And I did mention that when we talked about, again, about the living constitution approach. Reed versus Reed held that the word person does include women. And so essentially, even though the Equal Rights Amendment didn't pass and wasn't ratified, the 14th the 14th Amendment functions kind of as an equal rights amendment for women today. So that was a really important success. I'm going to now, in the next video, I'll talk more specifically about the legal framework that these create.